So, Ms. Evans, I mean, you were given, number one, you were given a great opportunity because you had a felony and they reduced it to a misdemeanor and put you on probation for 2 years. It looks like they gave you all types of help through JCDI, and you failed to complete your groups, didn't obtain a sponsor, you were testing positive, you were ordered to the Franklin North so that you could get some more intense help. You did okay in that, and then you got out and started struggling again. You were also ordered to go to Spindletop for mental health treatment so that you could get the help that Mr. Kimler is saying that you might need. And looks like they say you attempted to circumvent the requirements to obtain a sponsor. Your sister pretended to be your sponsor. You were placed on zero tolerance in JCDI. You tested positive. Good morning. Are you Ridley McKinney?
Yes, ma'am.
Or McKinley, I'm sorry. Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor. And I think we just go on counts 2 and 3 on this.
We do, but we're not going to go forward. We're going to draw allegations.
Okay, state's going to abandon 1. Will he waive the formal reading of that motion?
He will,
I just asked you that, I'm sorry. Mr. McKinley, in cause number 19-33345, I have a motion to revoke your community supervision. Shows that you were placed on probation August 1st of 2022 for the offense of aggravated assault family violence, and that was a 5-year term in prison that was probated for 8 years. Is that correct?
Yes.
It alleges in count 2 that you were at a location that you violated your probation because you were at a location other than your residence at approximately 10:24 p.m. April 9th of 2025. And is that true or not true?
It's true.
And then count 3 alleges that you are behind in your court assessed fees. Is that true or not true? And what is the status of that offense from count 1?
I believe it's been refused.
Because it was refused by our office.
Okay.
And the witnesses, it's the same as this one, but therefore we refused. We're not going to go forward with the allegation.
Okay. Is there a no contact order in the probation
No,
though?
they're married.
They're married, Judge, and I know the optics of it looks bad for the kind of officers that he's on probation for.
Y'all hold it down just a little bit. Go speak.
It looks bad for the kind of case that he's on probation for, but the complaining witness has come to my office. I've spoken with her.
We followed up with the judge. If we had it to move forward.
Okay, I just wanted to check. All right. Did you enter your pleas of true to counts 2 and 3 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for me to continue you on probation and order 60-day jail sanction, and it looks like you've got 44 days credit. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. McKinley is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2 and 3 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm not going to do that. I'm going to continue you on probation. I'm going to order a 60-day jail sanction as a condition for that. These allegations, you will get credit for 44 days. Here's the thing, something's going on, okay? And even at this point, if I think something's going on, the proof that is required for me to revoke your probation is not the same as it's required if we go to a jury. And if there's anything that happens again, whatever's going on between you and her, if y'all are not good together, then don't be together because you're going to end up in prison. The offense that you're on probation for is obviously very serious. You've already agreed, when you got this probation, you already agreed to that 5-year sentence in prison. You violate your probation in any way again, you've got the 5 years. I don't care if it's having to do with her, if it's being out past curfew, if it's not showing up for appointment, this is it. So whatever's going on, y'all need to get whatever help you need. If it needs to be separated, then you need to be separated. Otherwise, you might end up in prison. So you have to figure out what's really best, to be in a volatile relationship in front of your children or to be in prison. You understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. As soon as you're released from jail, first thing you do, report back to probation, get going on everything like you're supposed to. All right, good luck to you. In cause numbers 19-333-40 and 20-36095, on probation for theft of property and theft of service, and a motion to revoke has been filed in each of those cases. There's a new offense indicted 250297 with the allegation of theft of property. And so that theft new allegation is from offense date of August of 2023. And so obviously that was some time ago. There's a motion, let me get to the right paperwork. In each of these cases, obviously alleging that new offense. Mr. Rojas has filed motion in each of those motion to revoke probation cases that I set a bond. That currently they do not have a bond. Those are deferred, correct? Are they both deferred? Let me double check.
I think they're straight probations.
They're straight probations? Okay. So Ms. Leonard isn't necessarily entitled to a bond as if it were a deferred, but we're here to talk about that. Mr. Coleman has filed a state's reply to that motion. I have read and reviewed that and obviously understand Mr. Coleman's position. Mr. Rojas, you may go forward.
Call Ms. Leonard, John.
Ms. Leonard, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Okay.
Okay, Ms. Leonard, how long have you been in jail now?
14 months.
And it's my understanding that you've got a newborn baby at home. How was that child?
3 months.
All right, and there's a little, you're having, or before you were coming, you were having issues with breastfeeding or with feeding child.
Yes, ma'am.
Tell the judge about it.
My daughter's been breastfed since she was hospitalized at 3 weeks old. She also has a heart murmur. And since I've been in here, they've had trouble with her latching on to the bottle.
So let me ask, it looks like in these motions, the primary allegation obviously is that new offense, and then there is some community service hours, and then very behind in fees and fines. Other than those things, I've got probation here, and if you'll just state your name for the record, ma'am. And is there, other than those items, is there any other issues that you are having with Ms. Leonard that I need to be aware of?
No, Your Honor.
Okay. If this new allegation was more recent, I'm not sure what happened with the timeline on this, and for this purpose, I guess, doesn't really matter. But because it's been so long, and it looks like other than some fees and community service, everything else has been going well, I'm going to grant the motion to set bond in cause numbers 19-33340 and 20-36095. I'm going to set the bonds in each of those cases at $5,000 in each case. And obviously, if you make those bonds, the first thing you do is report to probation and do everything you're supposed to be doing while you're on probation. Yes, ma'am.
Is that included in the $10,000 bond for new charge?
You have 3 different bonds. You've got a $10,000 and 2 $5,000s. And so you need to get busy, because while this is pending, obviously would be, I would think, in your benefit to try to get some community service hours done, to get a job, start making some payments, show me and probation and the district attorney that you're trying, because just me setting bonds doesn't mean that you're out of trouble for this. You can still go to the state jail prison. So it's very important that you do everything that you're supposed to while you're on the probation, okay?
Yes, ma'am.
All right, we'll see y'all back at an announcement. All right, ma'am, are you Ariana Evans?
Yes, ma'am.
And this is 22 4163, and Ms. Evans is currently on probation for a lesser offense of terroristic threat against a public servant, a Class A misdemeanor, and previously in court entered pleas of true to counts 2, 3, 4, and 5. I received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, I have.
Are there any additions or corrections?
No, Your Honor.
I know, Your Honor.
I have something, Your Honor.
Yes,
The
ma'am.
GPS device, I was just emailed by Friday, 5:43, that it's been dead, the battery's been dead for 3 days.
Okay.
It's not being tracked at this point.
Okay, thank you, ma'am. Mr. Kimler?
Well, Your Honor, the recommendation obviously is not favorable to Ms. Evans. I mean, they do provide an option that if the court does consider maintaining her on probation.
Well, she doesn't want that.
Sir?
She doesn't want that, right? I mean, it says right here she just wants to do her time so she can move on with her life and put the case behind her.
Yeah, but I mean, if I like get the chance to like get reinstated, I'll do it too.
Which fee, Ms. Harris? What do you want?
If I can do the 60 days that they offer me and be off
Well,
probation.
60 days is off the table. So that's what the state offered, I think, before. Y'all are unagreed. It's up to me to sentence you today.
Yes,
So,
ma'am. Okay, so
What-
I'll let it be reinstated.
okay,
It is a misdemeanor, Your Honor.
I understand. Go ahead.
And obviously, the easy way for her to address this situation is to take the revocation and take jail time on it. However, the defendant's version does indicate some mental health issues. Obviously, probation is a system designed to try to keep people out of the actual criminal justice system in the future and avoid incarceration. So, just looking at this, since it is just a misdemeanor, I would suggest, just in her interest, and perhaps in the interest of the community, that she be continued, follow maybe the recommendation you adjudicate with 30 days up front, or no upfront time, but the mental health component be addressed with Ms. Evans to see if she can make progress with her so-called incorrigible attitude, which I think under the DSM may be diagnosed as an antisocial personality disorder, whatever her issues are from the mental health state.
Did you see that somewhere, or did you just make that up?
Well, I think that if they're saying she's incorrigible, I mean, obviously I'm not a mental health expert.
Okay, I just didn't know. I didn't see anything
She has
where she was diagnosed.
She hasn't been diagnosed with that.
Okay.
There's probably some issues there. With
Okay.
obviously, things that can be dealt with.
Judge, I think incorrigible and defiant means she doesn't want to do probation, doesn't like people telling her what she can and can't do. I'd ask that we revoke her.
So, Ms. Evans, I mean, you were given, number one, you were given a great opportunity because you had a felony and they reduced it to a misdemeanor and put you on probation for 2 years. It looks like they gave you all types of help through JCDI, and you failed to complete your groups, didn't obtain a sponsor, you were testing positive, you were ordered to the Franklin North so that you could get some more intense help. You did okay in that, and then you got out and started struggling again. You were also ordered to go to Spindletop for mental health treatment so that you could get the help that Mr. Kimler is saying that you might need. And looks like they say you attempted to circumvent the requirements to obtain a sponsor. Your sister pretended to be your sponsor. You were placed on zero tolerance in JCDI. You tested positive for alcohol. You left the state without permission. I mean, all right. I'm going to find that you entered your pleas of true to counts 2, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of terroristic threat against a public servant. I'm going to sentence you to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you were previously in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You do have some rights to appeal. Y'all need to sign that real quick, please, Mr. Kimler, and give her that bottom copy. And he'll give you that copy of that, and then you can go with the bailiff.
Thank you, Your Honor.
Thank you, ma'am.
Can I get my phone and my sister?
Talk to the bailiff, just talk to the bailiff. Yeah, come over here and get a thumbprint, please. Linton Arsenault, and Mr. Arsenault is charged with failure to comply with sex offender registration requirements. We've gone over before with, yeah, I think that was maybe with Mr. Lewis before you were appointed, and what the offer was and rejection, and what's the status?
The state's not gonna go any lower, Judge. That's the only offer, and it's gone today. So he can take it today, or he can go to trial.
Okay, thank you, Mr. Hoffpower. Mr. LeBlanc?
And I conveyed that to him, we discussed it, and my understanding is we all rejected it.
You want to go to trial? Okay, so I just want to make sure, and we've gone over this before, you understand if you go to trial and you're found guilty and those prior convictions are true, that you would be considered a habitual offender and your minimum punishment would be 25 years. You understand? And it looks like that offer that was made is for going on count one only for a 10-year term in prison. Again, you've got every right to reject that and go to trial. Just want to make sure you understand possible consequences, options, and all of that. All right, then we'll get it set for trial, and Mr. LeBlanc will begin preparation for trial. Yeah, it's one of those names that are on my list that I'm tired of seeing. It's you too, I'm sure. Good morning. Are you Adrian Housley? Mr. Housley was previously in court, entered pleas of guilty to, or plea of guilty in cause number 25, DCCR 0290 to theft of property with previous convictions. It's a state jail felony. And we pleaded as, no, and there were prior offenses, and so the agreement was for a cap of 10 years in the institutional division of the Texas Department of Corrections because of the criminal history before. I received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
Any additions or corrections?
No.
All right, Mr. Walker, you may proceed.
Judge, what I thought was going to be a long argument for us, we're actually in agreement with the PSI report, and we're asking the court to follow the recommendations and place Mr. Housley on probation.
Mr. Hoffpower?
Judge, we understand in light of what the argument is and the facts of this particular case. However, the court will leave it to the court's discretion. You see his criminal history. He has been in the penitentiary numerous times. So I leave it to the court's discretion whether or not it wants to place this individual on probation or in light of decision.
The underlying, what he ended up pleading to, was it a third or a second?
Second.
Second.
2 to 20 because it's so habitual.
That's what I wanted to make, okay.
Yes, sir.
Okay.
And Judge, if I may, what we're talking about is over a 4-month span with all the items added up, we're talking about an amount that barely gets over the threshold for a Class B misdemeanor. A 62-year-old Army veteran suffers from PTSD, and as the PSI report shows, he's a low-risk candidate for it. He's not a threat to it. He's went 15 years from his last offense without getting in trouble. He's showing that he's capable of fitting in with society as well as an interest to better himself, and that's why we're going to ask that you put him on probation.
Mr. Housley, on paper, you sure don't look like you deserve probation with your criminal history. Mr. Walker is correct, and the pre-sentence report writer has stated and shown me that it looks like you really are doing well in so many ways. With your history, it just kind of is beyond me, though, that you would go and do something really as minor as what you did, knowing with your history that it doesn't matter how minor it is. At some point, you got to stop, or you just keep staying in prison. Are you still working at Dragon Products?
Yes.
You've been, I mean, it looks like you're following through. You following through with your, is it the veteran services in Spindletop as well?
Yes, ma'am.
Okay. So here's what I'm going to do, Mr. Housley. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years. And I'm going to order a $500 fine and order that you follow all of the rules and conditions of probation. That will include that you are on the specialized mental health caseload to help with any issues with regard to PTSD and the things that you're going through. You'll be required to follow all of their rules and conditions as well. There's kind of two sides to this, right? And so deferred probation, a lot of times people see and wonder, well, why did they give them that opportunity at not having a conviction on your record when you have all the convictions? And that's for me. It's not for...
This courtroom hearing turned into a brutal reality check for multiple defendants hanging onto their final second chances. One man on probation for family violence narrowly avoided prison after the judge warned that even the smallest mistake could activate his 5-year sentence. A struggling mother received unexpected bond relief after emotional testimony revealed her newborn baby was battling health problems at home. But the courtroom exploded with tension when Ariana Evans faced the judge after repeatedly violating probation despite treatment programs, mental health support, and reduced charges. The judge listed failed drug tests, fake sponsors, alcohol violations, and even leaving the state without permission before finally sentencing her to 180 days in jail. Moments later, another defendant rejected a 10-year plea deal while risking a possible 25-year habitual offender sentence at trial. The hearing finally ended with a shocking twist when a 62-year-old Army veteran with PTSD avoided prison despite a long criminal history.